How to beat an assault with a deadly weapon charge in California. If you've ever defended yourself in a heated moment and thought that was the end of it, think again. In California, just holding something that looks dangerous can get you charged with assault with a deadly weapon, even if no one was hurt and you never touched that person. I'm Nana Knight, a former prosecutor and a certified criminal law specialist, and in this video, I'm exposing how fear and accusations can turn into felony charges and what you can do to stay out of prison. Because when the law blurs the line between self-defense and assault, your freedom depends on knowing the difference. Number 1, what is assault with a deadly weapon in California? In California, assault with a deadly weapon, or ADW, is defined under Penal Code Section 245A1. It's a serious felony. The law says that anyone who assaults another person with a deadly weapon can be charged with assault. Now let's break that down. What is assault? In California, assault does not require actual contact. It just means that someone allegedly took a swing, a stab, or even made a threatening move with the apparent ability to carry it out. You don't have to touch someone to be charged with assault. Deadly weapon. This could be a knife or any object like a bat, a car, or a bottle, even a sharp pencil. Anything that could cause serious injury or death if it's used the wrong way. I had a case one time where the police obtained a video of a person trying to run over another person with their car. Now, a car, we don't usually think of it as a deadly weapon, but it can be a deadly weapon if it's used to hurt or kill someone. You can be charged with assault with a deadly weapon using a car. And in California, if this happens to you, you can lose your driving privileges for the rest of your life. Now, in order for you to get convicted of assault with a deadly weapon, the prosecution must prove that the force you used was likely to produce great bodily injury, which means what you didn't just scare someone, it means you posed a real significant threat to their safety. And the prosecution has to prove this beyond a reasonable doubt. Example, if you take a single cotton ball and throw it at someone, that's not likely to produce great bodily injury. Versus if you take a crowbar and throw it at someone, well, that's likely to produce great bodily injury, and that could be charged as felony assault with a deadly weapon. Number 2, what does the prosecution need to prove? In order to get you convicted of assault with a deadly weapon, the prosecution has to prove beyond a reasonable doubt the following. Number 1, that you did some act. Number 2, that you did so with a deadly weapon. Number 3, that you acted willfully or on purpose. And number 4, that you had the ability to apply force to the other person. And here's the kicker. They don't have to prove that any injury actually occurred. That's why so many people are shocked to be facing felony assault with a deadly weapon charge when no one was touched, injured, hurt, or went to the hospital. Another example, I had a client one time who allegedly threw a water bottle during an argument and it barely missed the other person's head. No one was injured. The bottle didn't even touch the other person. My client was charged with assault with a deadly weapon even when no one was hurt. What's considered a deadly weapon? You might be thinking, but I didn't have a weapon. Well, California law defines deadly weapon very broadly. Sure, firearms and knives certainly qualify, but so do objects like a heavy glass bottle, for example, that's thrown at somebody's head, a dog that's trained to attack, even a pen if it's used to stab someone. So bottom line, it's not about what the object is, it's about how that object was used. Number 3, real defenses that work. Let's talk about what you can do to fight back. Self-defense. Now, self-defense in California recognizes your right to protect yourself and others when facing real threats of harm. If you believe that you or somebody else was in imminent danger and you used reasonable force to stop the threat, that could be a complete defense to a charge of assault with a deadly weapon. And the keywords here are reasonable and imminent. That means the threat had to have been happening right then, not something vague, not something speculative or in the distant future. The force you use must match the threat, which means you have to use no more force than necessary to stop the danger. For example, if someone rushes at you with a broken bottle in a bar fight and you swing a chair to protect yourself, that may be justified as self-defense. But if the threat ends, for example, if the person back down or walks away and then you chase them and pull a knife, well, that crosses the line from defense to retaliation. We see this defense come up in situations involving domestic violence allegations where one person claims self-defense and the other claims assault. Bar fights where alcohol clouds judgment and witnesses get confused. We also see this in neighborhood or road rage incidents where one party claims they felt threatened and acted to protect themselves or a passenger. It's also important to understand that self-defense doesn't require you to wait to be hit first. If someone takes an aggressive posture, threatens you verbally, or makes a sudden move and you reasonably believe you're about to be attacked, well, you can act to protect yourself. And what matters most is what you knew or believed in the moment, and whether your actions were reasonable under the circumstances. It's important when you are building your defense to dig into the details like surveillance footages, eyewitness testimony, past behavior of the alleged victim or the accused to show why your actions were justified and legal under the circumstances. Another defense comes up in the context of false accusations. Sometimes people make accusations for leverage. In a breakup, for example, a custody dispute or battle, or to avoid getting arrested themselves. Now, there could be many reasons why the person that's making the claim is saying they felt threatened by you. And this could involve situations like a divorce. For example, when one spouse is getting ready to file for divorce, they can try to get some sort of leverage in a custody battle by claiming they were assaulted, and they can try to get you disqualified from having custody of the kids. For your defense, you can also use the following defenses. You can also use to argue that you had no present ability. If you didn't actually have the ability to carry out the alleged threat, if someone accused you of trying to hit them with your car, for example, but your engine was off or you were blocked in by other vehicles, the case can fall apart. You can't assault someone with a deadly weapon if there was no real way of making contact or causing harm. Another defense is insufficient evidence. Sometimes the police only have the word of the alleged victim with no injury, no weapons that were recovered, no other witnesses, and no corroboration. It may be harder in these situations for the prosecution to get you convicted if there was no corroboration. Number 4, what happens if you're convicted? So, assault with a deadly weapon is considered a wobbler in California, meaning it could be charged as either a misdemeanor or felony. If it's charged as a felony, you're looking at up to 4 years in state prison. It is considered a strike under the California 3 strikes law, and you can also lose your firearm rights. If it's charged as a misdemeanor, you could still face up to 1 year in county jail. You can also face probation and fines, and of course, a permanent criminal record. Number 5, let's look at how a skilled attorney can help you. And here's where strategy matters. In many cases, a good defense involves presenting mitigating evidence very early on, before charges are even filed. This could include additional defense investigation, which includes witness statements, surveillance footage, or evidence showing self-defense. Submitting a pre-filing intervention packet to the district attorney can sometimes stop the charges cold. It can stop the case before it's even filed in court. Now, if charges are already filed, you should probably start investigating and building your defense right away. Contact a really good defense attorney and work with that attorney to build your case. That includes challenging the credibility of the witnesses, questioning how the weapon was allegedly used, and identifying holes in the prosecution story. With the right strategy, and if you act fast, you can get the case dismissed entirely or reduce your charge from a felony to a misdemeanor or to an infraction. But you have to act early. The sooner you get legal help, the more options you have. Now, we just covered how to beat an assault charge in California, but what if you did actually injure someone, but only in self-defense? How do you get your case dismissed? Check out this next video where I break down the ins and outs of self-defense so you can get your case dismissed, and I'll see you over there.